Here, I was asked to speak about British surrogates' views on their experiences, the existing law in the UK, and potential law reform, which we have been looking into in the UK. More so than here, I think. I'm getting the impression. But some of the things I'm going to say have already been said today, just in a different context. So there's not necessarily going to be much in the way of surprises. First, I should probably give you some context. So you probably know a lot of this anyway if you're studying stuff. But so we have a law regulating surrogacy. It's nearly 40 years. It'll be 40 years old next year. But it is generally accepted that it doesn't align with many modern family forms, how surrogacy actually works in practice in the UK, and crucially, the best interests of children and families. And so there's been an increasing awareness of this over time. And largely this comes down to the fact that the 1985 Act, the Surrogacy Arrangements Act, was a very hastily passed measure kind of in response to a moral panic about a commercial surrogacy that took place in the UK in the early 80s by a woman called Kim Cotton, who was all over the news. The baby Cotton case, as it became known, was a catalyst for having this law passed, which was coincidentally at the same time as we just had a royal inquiry into, not royal, a government committee of inquiry into the whole area of human fertilization and embryology, which resulted in what's known as the Warnock Report in 1984, which came down kind of heavily against surrogacy because, as Mary Warnock herself, an esteemed moral philosopher, acknowledged, she just didn't like it. She didn't get it. And she was very generous, many years later to say, to admit that it was a gut instinct. I didn't like it. I had my own babies. I couldn't imagine giving them away. There's no amount of money that would have enticed me to give them away. And I misunderstood what surrogacy could be. And, she came back to that several years later. We have later laws as well, which impact on the regulation of surrogacy, in particular how legal parenthood is transferred from the surrogate, who is always the legal mother at birth, currently in the UK, under the law, and the intended parents can apply for what's called a parental order, which is a court order which transfers the legal parenthood to them, subject to certain criteria being met after the birth, with various timescales involved in that. I should say that the number of children born through surrogacy each year in the UK is inevitably quite small. Our Ministry of Justice collates the data on how many parental orders are granted. And that's not to say that there are some people who do surrogacy and then don't apply for a parental order. There are very many reasons why some people don't. And there will be a very few surrogacy arrangements that are formalized by adoption afterwards. But parental orders were created to kind of replace adoption as the means by which parenthood is transferred. But the data that the Ministry of Justice collect reveal the number of parental orders granted to applicants in England and Wales. So Scotland has its own register. Started from the first year records were collected, which is 2011, from 117 surrogate births, going to just picking out some examples. 2019, there were 444, which was a peak at the time. 2021, there were 435, so they've gone down again, although COVID happened in between those 2 years. And 2023, the last complete year for which data is available, there were 513 parental orders granted. So 500 or so, 450, 500 or so children per year are subject of a parental order out of a population of over 60 million people. So because the law is as it is and there are unsatisfactory conclusions reached, and in particular, the best interest of children is not always the outcome that the law allows, there was a lot of campaigning and sort of legal background work. There were legal cases where judges criticized the law and what they were able to do within the confines of the law. which led to the Law Commission of England and Wales, jointly with the Scottish Law Commission, to hold a joint public consultation on surrogacy starting in 2019. And this came about because, so weirdly, our law commissions consult on what they should consult on. So they had several ideas. Some things were like boring, like leases and regulation of leases, and currently doing a thing about disposal of the body after death and things like that. So, but they consult on the things that ought to be consulted on. And they put forward the idea that surrogacy should be subject to public consultation, and that pre-consultation received the most responses they've ever had, which were all in favour of there being a public consultation on surrogacy. So it became kind of inevitable. The timing was unfortunate. They started in 2019, and then obviously COVID locked everything down for us in March 2020, slowed down their review quite significantly, and the report and their final recommendations was published only last year, in March 2023 in the end, having been delayed, I think, for about 2 years from when it was initially supposed to have happened. And alongside the recommendations they made, some of which I'll touch on later, we have sitting there a draft new surrogacy bill with an idea to repeal the Surrogacy Arrangements Act and the relevant provisions of the Human Fertilisation and Embryology Acts that regulate parenthood, and put that all together in one bill that just regulates, or one act that just regulates surrogacy. I just want to touch, I'm not going to go through this quickly all the way, and I'm kind of hoping you can see it, that it's not too small, but just gives you a picture, a flavour of the sort of pathway that's taken place, of this sort of long road to reform. And someone earlier mentioned that reform can take a long, I think it was the senator, can take a long time. It's not an immediate process. And I remember I started working with the Surrogacy UK, one of the UK's non-profits, as the academic member of their group pursuing law reform in 2015. And I remember one of the people I was working with, who was herself a parent through surrogacy, said, "Yeah, we'll have this fixed by Christmas." She, in real life, is a project manager and does get things fixed, pretty fast in the world that she lives in. And I was like, "Yeah, no, Natalie, you've got no idea." But I mean, that's nearly 10 years ago. So so we got the law from 1985. Everything was very quiet for a very long time, and it wasn't until well, I mean, the flag I haven't got in there should be about 2009, but I put it under the 2014 flag. There were increasing criticisms from judges from about 2009 onwards, and that's when international surrogacy cases started reaching the High Court in England, and people applying for parental orders when they'd gone overseas to have children by surrogacy. And so that raised particular issues that hadn't been seen before in the UK courts, and that's when they first emerged. So that led to various things: coverage in the media, debates in the House of Commons, judges becoming increasingly critical from that period onwards, of the law and what they were, constrained by, and sometimes they found ways around those constraints. So, for example, what's not on 2014, there was a case called Re X that was decided, which was about the time limit that intended parents have to apply for a parental order once their child is born, which is written into legislation as 6 months. Intended parents must apply within 6 months of the birth of the child in order for a parental order to be created. And the judge in that case, who was the president of the family division of the High Court, said Parliament can't possibly have intended that at 6 months plus 1 day, that child's legal parenthood, the opportunity to be recognised as the child of the people who were taking care of them, would be removed. And so that's essentially just been wiped out from that case onwards, the 6 month time limit, which is, if you look at the legislation, it's there in black and white, but there are several court cases since where that time limit has been nowhere near adhered to, including a case about 2 years ago where a 23-year-old man became the subject of a parental order, creating the link to his intended parents who happened by surrogacy 23 years previously. But obviously there are reasons why you want the people who you think your parents are to be your legal parents. not least things like inheritance and succession. So that kind of thing came in. So anyway, lots of things happened over a period of time. I mentioned Mary Warnock before, 2016, she wrote an introduction to an edited collection I did, basically saying, I think I got surrogacy wrong, and actually I do think the law should be reformed now. That same year, there was what we call a declaration of incompatibility against our legislation, and that means that part of our legislation was incompatible with our Human Rights Act. And that was the idea that only couples, as the legislation is written, only couples can apply for a parental order. And this was pursued by a single man who was intending to had become a father through surrogacy and wanted to become the legal father through surrogacy, and was unable to apply because he wasn't a couple, he was only a single person. So the court in that case ruled that provision of the Act incompatible with the child's human rights, which means when there's a declaration of incompatibility under our Human Rights Act, the government must do something about it. And they can't just go, oh, right, okay, sorry, but they had to actually do something. And so you'll see in 2018, the last one on the list is that there was a remedial order passed, and that's the remedy for the declaration of incompatibility, order which amends the legislation, and now single people can also apply for parental orders. We know about the Law Commission, we know about those kind of things. So they did this consultation paper, there was lots of debates in Parliament, there were lots of academic conferences, all that kind of thing, and then we get to 2023 when they publish their recommendations. When the Law Commission publishes recommendations in the UK, there is another statute about the Law Commission's operation that says that the government must provide an interim response within 6 months and a full response within a year. Things weren't, terribly smooth in our government around about that time. Things weren't going terribly well. So that 6-month thing didn't quite happen, but we did get a response from the minister at the all-party parliamentary group meeting in November 2023, which basically said, yeah, we haven't got time in this parliament. There's going to be a general election at some point. We don't know when, but we're not looking at it before then because, washing our hands of it, basically. So that was the interim response, and we are still waiting for the new governments. And, who knows whether that year, what does it start rolling again from when a new government comes in? But we're waiting for a response from the new government. It's owned, the bill is owned by the Department of Health, so that would be who we're waiting for the response from. So what have they actually recommended? So the point I want to, they've recommended lots of stuff. I mean, all kinds of things about, wills and intestacy and all, like really boring things about the forms you fill in for courts and stuff like that. But the key thing, and kind of what I've been pushing for, I guess, throughout my career, is the change to, or potential change to, legal parenthood following surrogacy. So they have proposed a new pathway to parenthood, which, if followed, will allow the intended parents to achieve legal parenthood at birth, which is something that is desired, obviously, by intended parents, but also following surveys that we've done in the past by most surrogates who don't want the responsibility or the legal parenthood and don't view themselves as the mother. There are various things that you have to do to be on this pathway, like lots of preconception things must happen. There must be informed consent, which is checked. There must be medical and criminal checks performed on all parties, all adult parties. They must all have legal advice. They must all have implications counselling. And all this is done under the auspices of what is proposed to be regulated non-profit organisations. So currently we have some non-profit organisations that operate in the sphere of surrogacy and support people through surrogacy arrangements. And it is proposed that those, or certain of those, if they apply, will be regulated by a new arm of the Human Fertilisation and Embryology Authority, which already regulates fertility treatment and related science in the UK. So they will become RSOs, regulated surrogacy organisations. They will support the completion of agreements known as regulated surrogacy agreements, RSAs, and They will sign off that everybody's done everything right on a confirmatory statement called a regulated surrogacy statement, an RSS. Within this model, it is proposed that we maintain an expenses only model, but maintaining is a strong word because actually at the moment it's quite flexible and people do it as probably best practice out there. Most people follow the same kind of idea, but it's going to be more tightly drawn. So it will be receipted expenses. That is proposed, and it is proposed that this is done in a different way. So many organizations at the moment support sort of working out what the expenses will total and then dividing that up and paying on a monthly or weekly basis, depending on what suits the parties best. And there's ways of reimbursing or topping up at the end, and they're proposing like not to do that. And I think that's probably the biggest pushback that's come from the organizations on this, and just saying, you know, allow us to have that bit more flexibility, please, because not everybody can afford it all in one go, and, you know, all that kind of thing. The other thing that's different is that the regulated surrogacy organizations will be allowed to advertise. So they'll be allowed to advertise that they support surrogacy arrangements, that they can engage in. It's not matching in a sense, it's bringing people together and allowing them to match. So that the actual matching, there's only one and a half, I'd say, agencies or organizations in the UK that currently positively match people rather than sort of just put people in situations where they can do that themselves. So at the moment, advertising for or as a surrogate or any services connected to surrogacy is prohibited. It's a criminal offence under the Surrogacy Arrangements Act. What isn't is paying surrogates. I mean, it's a common misperception that you can't pay surrogates in the UK, but that is nowhere in the law. It just doesn't seem to happen. What is prohibited is the payment of any third party intermediary. So that's why our organisations are non-profit. They are only under the legislation allowed to charge such a sum as to cover their admin costs. The surrogate retains her right to withdraw consent to this, not consent to the agreement. Obviously, she retains her right to withdraw consent to that, but to the legal parents attaining parenthood at birth. So there's that sort of like, hang on, they're going to get legal parenthood from birth, but still there's this veto, which is one of the things that has prompted calls for reform in the first place, and that this will have different effects pre and post birth. If she withdraws her consent to the intended parents being legal parents before the birth, then she will be legal parent at birth, and the intended parents will, as they do now, have to apply for a parental order with some proposed modifications to the parental order system, just making it a bit smoother and taking away some of the weird bits that are in there. And if she withdraws consent after the birth, the legislation will still say that the intended parents are the legal parents, but will note that consent has been withdrawn. And if she wants to, because sometimes this consent will be withdrawn not because she wants to keep the child. In fact, there are so few cases in the UK, I can count on less than the fingers of one hand any time where the surrogate has refused to hand over the baby because she wanted to keep it. That if she did want that, she would have to apply for a parental order herself. But if she doesn't want that, the court just sort of goes, well, hang on, what's happening here? And so they still have to make a best interest declaration just to say that, yes, this is the position of the legislation and we agree and nothing's going to change on the legal parents. So it would be for the state to step in if there were any kind of concerns. Just a sort of visual guide to this new pathway. This is actually from the Law Commission's document themselves. So you can see like the line is drawn at conception and most things are front loaded. Before that, you can see the bit about the surrogate withdrawing her consent. And then afterwards, post-birth, there is the intended parents become the legal parents. There are some eligibility criteria. Surrogate must be at least 21 years old. That's not currently the case. Intended parents must be at least 18. There are some people who are sort of arguing against this and saying both ages should be older, but they tend to be generally anti-surrogacy. There are not many instances where either intended parents or surrogates are anywhere near those ages in the studies I've done. Where there are two intended parents, as now, they must be married in a civil partnership or in what has been undefined for a long time, an enduring family relationship, whatever that means. But the courts have interpreted that even in a platonic relationship, and allowed two people who are in a platonic relationship to have the parenthood of a child they jointly tried to have through surrogacy. At least one of the intended parents must have a connection with the UK, either domicile or habitual residence. At the moment, it's only domicile, which that proves a bit problematic in some cases. As you'll see, though, from this, I don't know if that works. So the regulated surrogacy organisations are proposed to have a significant role. And I think this goes to something that was touched on earlier, that the organisations here are subject to sort of no regulation at all. And that might be where some of the problems stem from. And actually, at the moment, there's not a lot of problems that stem from our organisations, but it's still proposed that they're going to be regulated. And that means, you know, licensed and inspected, and subject to potential closing down if they're not adhering to what is set out in the law. So that is perceived as a positive thing by the organisations. It gives them legitimacy that they, you know, if you're in the sort of surrogacy world at the moment, they already have, but if you're outside the surrogacy world at the moment, you know, you might perceive them as a bit dodgy, you might think they're in it for the money, and actually, you know, when you drill down into it, they can't actually make profit. So what next? Well, we need the response, the actual response from the Department of Health, and then they must set aside parliamentary time to actually bring this bill before Parliament, have it debated. There will be quite a lot of public debate on it, and it would be, you know, my contention and many others that such debate should be informed by lived experience of people who've gone through this process or are going through this process. We need MPs and peers to be engaged and interested in the debate. Unfortunately, the all-party parliamentary group that existed before the election dissolved because there was an election. We're currently working to re-establish it, but the driving force behind it, surprisingly, a Conservative MP lost his seat at the last election. And so we need a new chair, and we're working on that in the background at the moment. We also need the organisations to become regulation ready, and they have been working on doing that since the recommendations were passed. So they are getting all these things in place. They're already doing all the checks and things at the times they're supposed to be doing the checks. So they are doing that pathway already, so that they become regulation ready, and the HFEA needs to be ready to regulate. Its position is that it needs money from the government to do so. It needs resources to be able to do that, as well as all the things it already does. And it will need to train people up and get the right people in, and, you know, all those kind of things. So the issues are that, you know, as I said, nothing happened during last Parliament. We're trying to, you know, get the momentum going again. Meanwhile, and potentially helpfully, things happen elsewhere. Ireland has recently legislated surrogacy. They have an actual act that was passed and up against much opposition, but gets there in the end. New Zealand is nearly there on their forms, and there's various other countries doing it. But then at the same time, we have the shadow of Italy, which is, you know, geographically quite close to us, which is just not, well, which is maintaining its ban on surrogacy, as with many other European countries, but has just also prohibited people going overseas for surrogacy as well. At the same time, there's been, you've probably seen, various surrogacy scandals hitting the news. There's in Argentina and Cambodia, various places where they have, and Crete in Greece, where surrogacy is legal, supposedly altruistic, where there have actually been trafficking situations that have happened when it's been found that women have been trafficked for the purposes of surrogacy. And that doesn't necessarily put debate, even in somewhere like the UK, on a very good footing, because people just hear that and think that that's what surrogacy is. And this feeds into some strong voice minority opinions, which I want to come back to later, that are becoming increasingly loud in the UK and you know, potentially quite dangerous for the purposes of reform. I would call their position very ideological in its basis. I've I've termed it neo-paternalism, but I'm open to suggestions on this. I think their positions need to be challenged where possible with facts, with evidence, because they appeal to emotion quite a lot of the time, and they are calling for all surrogacy to be banned, because you can't prevent things like the trafficking and all that kind of thing. But I think that would be detrimental to everyone. So on to the lived experience, which I think should inform the reform. So I had a secondment away from the university for 2 years in a fertility clinic in London, who kindly gave me access to their entire database, and allowed me to contact the surrogates that had been treated there since they began surrogacy, which was a period between 2014 and 2021 when I started there. So there haven't been very many studies on UK surrogates, who they are, how they navigate the process, what they think about the law, all that kind of thing. So that sort of experiential thing that Vanessa was talking about earlier. So I wanted to try and understand who surrogates were, why they did it, and what they thought about the whole process. And because at the time, 2021, what we had was the Law Commission's initial proposals in their consultation document, but we hadn't yet got the full report. I was asking about what they thought about the initial proposed reforms. So similarly, there was, so I did a survey initially about the stuff, and then followed up with some interviews, semi-structured interviews over Zoom over a period of winter 2021 to 2022. And we shall see what they say. So demographic stuff. So there was 40 steps. So there were, in the time period we were talking about, so it was 2014 to 2021, the clinic had overseen 119 surrogacy arrangements. And with the exclusion criteria and ability to contact the surrogates, 100 surrogates were eligible to answer the survey that was sent out, and we got 47 responses. Most of them from the latter end of that time frame, because some of the people have done surrogacy so long ago. I got to get a couple of responses going, I can't even remember. I can't answer your questions because I barely remember doing it. The mean age of the surrogates was about 36. There was a range of 23 to 65. The 65-year-old was the mother of the intended mother. Most were married at the time of their treatments, and this in the UK, under the UK law about parenthood, makes a difference, because if they are unmarried, one of the intended parents who is genetically related can also go on the birth certificate with an unmarried surrogate. So you still have to correct that with a parental order, but it means that you get parental responsibility from the point of birth registration. Of them, all but one had their own children already, and most define themselves as white British, which goes against some of the anti-surrogacy voices that say surrogacy is always exploitative of minority groups. Their occupations are, not necessarily surprising. It tallies actually with what Surrogacy UK say about their surrogate membership. Lots of them, or the majority, were probably in things like midwifery, nursing, healthcare, teaching, or childcare related professions. But there were some in business admin, management roles, 3 solicitors, weirdly, 2 students and 2 stay-at-home mums, and there were various other people doing that kind of thing. But the majority in those kind of educational or childcare or healthcare professions. Similarly, we asked about household income. The figure on that first one ranged from below £29,900. That seems like a very specific, niche sum there. But that had recently just been published as the mean average wage in the UK at that point, of household income. And so that's where we started, as it was anyone below that. So we had a fairly big range. Most of the responses, 85%, indicated below 70,000 household income, and 4 reported over 80,000. I should put a caveat in here that the the question wasn't necessarily interpreted. So from the follow-up interviews I did, the question hadn't necessarily been interpreted to mean household income. So some of these surrogates answered the question based on personal income rather than household income. I should have put both questions in to do it. So some of the surrogates were single, and unsurprisingly, the lower household incomes did fall within that group. Who they, I've put the word journeys, I'm sorry, for those who, but it is a word that is used by both surrogates and intended parents. And I think, the answer that was given earlier, certainly from the intended parents' perspective, it is a journey. It's that sort of long, arduous journey for a lot of people. So most, but only just over half worked with heterosexual couples. 40% worked with male same-sex couples, and that might be a particular profile of the clinic, which has a bit of a reputation for being very LGBTQ friendly. One surrogate worked with a single woman, which is really quite unusual, I think, in what's widely reported about surrogacy, and one with transgender intended parents, and where both of the intended parents were transgender, one male to female, one female to male. 28% of the surrogate journeys were with family and friends. So various, sisters was the most common. But I mentioned one mother already, but in 2 of these arrangements, the intended mother's own mother was the surrogate. 10 other surrogates describe themselves as friends, best friends, old friends with at least one of the intended parents. So you got 13 inter-family relationships and 10 friends relationships. So that's, pretty much half. Just over half, so, the other half met their intended parents through non-profit organizations or online. So there's 15 met through a non-profit organization here, and some of them are listed. The top 3 there, COTS, Surrogacy UK and Brilliant Beginnings, and there's one that only established in 2021 called My Surrogacy Journey, which doesn't feature in this data because it only established in 2021. They are the 4 that are endorsed, would be a strong word, but they are in the guidance that is provided by the Department of Health. So COTS is they're there in age order, like how long they've been established. 9 said they met online, by which they also mean, various Facebook forums and things like that. The idea about what led them to surrogacy came up from the interviews. Many had experienced their own fertility issues or pregnancy loss before they came to surrogacy, so they had that sort of empathy. So S13, so in the interview documentation, I've just had to, they didn't want pseudonyms, so we just went for numbers. So surrogate 13, said that she'd had IVF for her own kids, age 7 and 5 at the time, and had experienced infertility and wanted to help. She knew what IVF was like, so she wasn't averse to doing it again. She says she bumped into a past client, not a surrogacy client, like in her normal work sphere, who'd had children through surrogacy, and that sowed the seed for her to become a surrogate for somebody else. Others had friends and families who'd experienced fertility issues or pregnancy loss as well. That same thing that is repeated about enjoying their own pregnancies or finding them easy came up. And some, quite a few actually, about 3 or 4. So there were 25 interviews, so 3 or 4 of them said they were inspired by reading about, a newspaper or a magazine article about surrogacy or seeing a surrogacy speak on TV. So there's a morning TV program called Good Morning Britain, which was mentioned a couple of times. I saw a surrogate on a morning TV program when I was a student. It stayed with me. I thought about it often. I had my own son easily, and surrogacy was still at the back of my mind. Came out. So there were quite a few people who said something similar. How the journey began. So a lot of them came to surrogacy by having undertaken internet research, and they discovered, the sort of web-based, what are known in the UK as independent surrogacy groups, the Facebook groups, and things like that. So there's lots of quotes that reference Facebook groups or joining conversations on Facebook and and finding out stuff. You know what's not mentioned? Mumsnet. Everybody hates Mumsnet and all the surrogacy world. Thank you. And they found some of the non-profit organizations as well, which have all got really sort of good websites that tell you lots of things. And even if people didn't eventually register with one of these non-profit organizations, many of them sought initial information from those websites about things like getting legal advice, making sure wills were up to date, or life insurance, or that kind of thing. I just want to pick one of these quotes here. Surrogate 1 said she joined a few groups to be nosy, saw sad stories, did this thing. And then I discovered the government document. Within a week, I knew all the laws. The government document she's referring to is the Department of Health guidance. And they produced, I think it's the world's first government official guidance on surrogacy, but I've yet to confirm this. Published in 2018, the Department of Health issued 2 parts of guidance, one for people going through surrogacy and one for the people who care for the people going through surrogacy. And it is, quite detailed in what it does, and it explains the law, and it explains, what you can and can't do. How the journey was experienced, a lot of comments on that kind of thing. The best thing I've ever done, it's massive, those kind of things. There were lots of questions about, lots of people referred to other people's reactions to them being a surrogate. So questions about how will you be able to give the baby up and that kind of thing. So surrogate 18 in the middle there, everyone's question, will you be able to give the baby up? And I said, it's not my baby. I knew that if I used my own egg, it might be different. And quite a lot of them said that. So all but one of the surrogates in the survey and in the interviews had not used their own eggs. Only one surrogate had used her own egg in a very weird, she had to donate it to herself kind of way because of the way consent forms work. It's bizarre. So quite a few mentioned that they might have felt different if they used their own eggs, and said they wouldn't have done surrogacy if they had to use their own eggs. So there's that sort of connection with the genetic link there. There were a few comments like surrogate 18 at the bottom there saying that hospitals weren't necessarily sort of up on what the Department of Health's policy was. And one of them, social services was called. But by the time they got there and explained it's a surrogacy arrangement and it's fine, and it was like, it was all sorted out. But, that initial panic of having had social services called. There's another one who said the police had been called by the hospital. And there's various stories about having to hand over babies in hospital car parks because the hospital doesn't want to be liable in case that's wrong. So it's all a bit strange. So I asked them also what they thought about the pathway to parenthood. Hasn't changed much since its initial, since the recommendations were initially made in the consultation. It didn't change much in the final iteration. So I asked them, explained to them what the steps would be, and asked them what they thought about it. And 39 were flat, totally agree. That's exactly how it should be. 4 said they didn't know. Most of them were, pre sort of 2016 surrogates, so they didn't know enough about it. They were totally sort of disconnected from surrogacy. They'd done it a long time ago. They hadn't thought about it since. So a lot of the surrogates who'd done it, particularly the ones who'd done it through one of the non-profit organizations, had maintained contact with the organization and were still sort of in the surrogacy world to a certain extent. So they knew what was going on, even if they hadn't been a surrogate subsequently. 2 who said they didn't agree with the pathway wasn't because they didn't think surrogates shouldn't have legal motherhood at birth, but because one said it would be long and costly and an unnecessary process. Another one suggested that there shouldn't be details stored in a national registry, which is one of the other provisos for the pathway. So we have a donor conception registry, and it's proposed that there will be a surrogacy registry as well, where all details of all the participants are kept. And she just was anti that, so therefore anti the pathway. Very quickly, can I just have 2 minutes? Very quickly, so on this, their individual responses for supporting the new pathway under which surrogates would not be legal mothers at birth and the intended parents would be. 31 of them gave detailed reasons, which were then sort of transcribed and coded and things. And 4 themes came out of this. You know, it's sensible came up quite a lot. That it best reflects surrogates' ambitions and their understanding of the role came up 7 times, and that surrogates were saying it enables intended parents to have rights and responsibilities from the outset. There were quite a lot of comments in the interviews about things that had happened, that only the surrogate could give consent to medical treatment of the newborn, for example. And so there was like the surrogate had already gone home and the hospital's phoning the surrogate in the middle of the night, whereas the intended parents by the bedside and things like that. So they were quite happy that this would be resolved by the intended parents having legal parenthood from birth, and better reflecting all participants, including the baby's best interests, which is kind of the same thing but expressed differently. From the interviews, I just wanted to say, like, they picked up things like, this is the intention, it seems sensible, the surrogate should not be the mother, all that kind of thing. Surrogate 18 said the pathway was brilliant. She said that was the hardest bit. One of the nurses knocked and said, "Mum." I said the mum was next door, meaning the intended mother. And the nurse said, legally, I know I gave birth and everything, but I'm not the mother. So there's this, you know, very big sense that the language used in hospital was often quite inappropriate, and they didn't want to be called mum, and they preferred it for someone else. There's another quote elsewhere, and someone's talking about her sister as the intended mother, who said, when the nurse called my sister mum, she broke down in tears, and that was what it was all about. That's what brought me the joy, that somebody had finally called her mum. I was like, oh, like melting. So yeah, so all that kind of thing. Views on advertising, they're generally positive about advertising, but they didn't really have much to say in the interviews about that, other than that there were really diverse views about who should advertise and what for. But they kind of came to the same conclusion, that the biggest level of support was that the non-profit organisations should be the ones to be able to advertise, and the least disagreement was also in that column as well. I wanted to get on to like the sort of anti-surrogacy stuff, but I don't think I've got time, so I can do that in the questions if you like. But I was just going to say about the views on expenses and payments. The same kind of thing came up earlier, that there was like a going rate that wasn't exceeded. It tended to be somewhere between £12,000 and £15,000 as an expenses reimbursed, but one surrogate came out and said it was less than £1,000. It was my sister. She lived around the corner. Like, what expenses are we talking about? You know, so like nothing was sort of massively overinflated. There didn't seem to be sort of anything from that, but they preferred to keep an expenses only model. They preferred it to be transparent, and they didn't want there was a lot of objection to it going towards either a paid surrogacy version or a commercial surrogacy where everything is commercial. Lots of comments like, I don't want it to be like the US, because you'll get the wrong kind of people coming forward to do it. So that I heard that earlier, and it was replicated in this one as well, that they were just sort of saying, people won't do it for the right reasons, and you'll get the wrong people coming forward if there's a financial incentive. So I'll just leave it there. And yeah, thank you.
So really, really interesting to hear about your research. Of course, I've read a lot of your work previously as well. And so one of the things I was thinking about when you were talking about, you know, it's a misconception that paid surrogacy is illegal in the UK, but it's not actually happening. So there are a lot of norms that are kind of operating in this space that connects to some of what Dr. Katapan was talking about before, and some of the things I've explored in my research as well. I'm wondering why, like, do we have any sort of sense about why it's become, why did nonprofits develop with the current regime in a way that didn't happen, let's say, in Canada?
Yeah.
And why are people in the UK more rule following?
They like to queue. I think so. Our initial legislation was, you know, kind of down on surrogacy, and was hoping to sort of push it away and make sure it didn't happen anymore. Obviously, that's not the case. Similarly to here, when you're talking about the agencies earlier, a lot of them are run by ex-surrogates or parents through surrogacy or a combination of both. And I don't know why they formed, but they did, and it's in the legislation that they must be non-profit. So I think that probably helps. It's there that they must be non-profit, and then there wasn't a change till the 2008 Human Fertilization and Embryology Act that sort of acknowledged that actually they may have costs in doing what they do, and so they were allowed to charge like a membership fee. And the costs vary, so they're all non-profit notionally. Surrogacy UK's membership cost is something like £1,200 for a year, so it's not extortionate by any means. They're probably one of the cheapest running at the moment, but they also are a bit more hands-off than the others. So the one that I mentioned, well, 1.5 that match, so Brilliant Beginnings that was mentioned on there, I mean, they're really expensive compared to Surrogacy UK. But they offer a very bespoke service. The person who runs it is a family lawyer. So the legal advice is bound up in the price, and they do actually match, and they do psychological screening of surrogates. And do you know what I mean? So like you can see why they're more expensive, but it's a bit more of a, sounds like it's a terrible word to use in this context, but it's a bit more boutique than Surrogacy UK, which, you know, it prides itself on having a community that is kind of self-generative. And so that, you know, if you follow them on Facebook, you'll see they're having socials all around the country all the time. And there's, you know, people are posting selfies like, we're on the way to the Bristol social. And then, you know, afterwards it's like, thanks so much for whoever member has organized the social. And it just seems very sort of organic. I don't know why it's grown like that. I think, I mean, I was talking earlier, wasn't I? But I think geography has something to do with it, that we've packed, you know, nearly 70 million people into a country the size of about Ontario. And you have 40 million people spread far more widely, and a federal thing. And so I don't know, we have the NHS, which helps. You know, I know healthcare here is not like it is in the States, but people don't have to worry about that kind of thing, and health insurance. And so it is just, yeah, it does just seem to be a sort of very organic thing. And I think that the change in tone from maybe not 1990, but a bit later onwards, that surrogacy was actually, you know, a legitimate form of family building. We have the HFEA, which I think helps. So fertility treatment is very well regulated, tightly regulated. And I think as a sector, the fertility sector in the UK is, you know, well respected because of that. And so I think because most surrogacy is still just gestational surrogacy, is involving a clinic. So I think all that plays into it, but I don't know is the answer to your question.
There definitely wasn't going to be a clear answer. So that's
no, I'd love to know the answer, but who knows? But I mean, one of the other things I think is that the organizations are so happy that the recommendation is that they be regulated. I mean, it came as a bit of a shock, actually, that was their response. It's like, yeah, you have to regulate us. And actually, you know, so that's going to incur some costs and things like that. So they will still have to be non-profit, but costs will go up because of the inevitable costs of regulation and having to meet regulatory requirements. But they're like, yeah, fine, bring it on, because of the legitimacy and being able to, you know, sell that to the people who come to them.